Yeah.
So today ni ile siku ya wakili quick one. Mnanipatia pro bono.
Yes.
All right, so before we get into it, right? Unajua lawyers, I see how you guys behave on Twitter and everything. The other day I saw the cabinet secretary for what's it called, for transport. He was talking to another very was it Paul Muite or something? I think so, right? And how you guys refer to each other as, you know, especially like senior counsel, you gotta give them the due diligence. So I'll start with Liz. Hey, profile yako Liz. Hey, first and foremost, right? So Liz Lenjo is a founder and managing consultant at the My IP Legal Studio. She specializes in intellectual property, entertainment, media, fashion law. We're gonna get into all of that. So IP first and foremost, it can even go into fashion.
Yeah.
All right, that's brilliant, right? Liz is also the chairperson for the Copyright Tribunal and has specialized in so many different, cases and all of that, and also helped in establishing of the Copyright Act of Kenya. Alafu sasa tuende kwa Mutua Mutuku. That's a very dope profile picture on LinkedIn. Takufuata tu saizi.
Thank you.
Now, he is he's all about intellectual property and data and compliance. He's a legal practitioner in the country. He's a regular contributor to the Daily Nation and Business Daily. He was also a board member of the Rotary Club of Muthaiga. You've previously served as a board member at the Kenya Fashion Council and the Private Bikers Association of Kenya. He's a member of the LSK's Young Lawyers Committee, as well as the LSK's Nairobi branch of Information, Communication, Technology, and Intellectual Property. Hey, boss, you guys bana, mumesoma.
Kizungu tumingi.
Kizungu kubwa. All right. So let's get right into it, right? So IP, you broke it down very well, right? But I want to now break it down into like I was reading music, fashion, and all of that. So IP in terms of like music, fashion, and all of this, how far does it extend?
So, Calvin, thanks for that.
Yes.
So, I would want the basic person to understand this. When we talk about IP, we basically mean the creations of the mind. And I don't know if at least people my generation might relate to this. Was it Banjuka remix where is it this artist who says akili pia ni muscle? I don't know who said that line.
So that DNA, that's DNA.
Akili pia ni muscle.
Yeah.
That is basically IP. Using your mind to create. And now there's so many facets of IP.
Okay.
And one of them, of course, being copyright. And I know Liz has wealth of experience. She's a god here of copyright.
Yes.
And it's basically works that protect anything that has artistic value.
Okay.
Whether it's a song, whether it's a poem, whether it's anything that you've written down, whether it's a tattoo a tattoo artist. So anything that has artistic value that has been put down, expressed down in a medium, that's copyright. And then we have...
I like how you said that. Particular. It has to be in a medium.
In a medium, yes.
Because kaiko kwa akili amujui.
IPA protecting ideas.
Yeah, of course.
Yes.
So medium is the core word.
Yes.
All right. Continue.
And IP doesn't need to be copyright doesn't need to be registered. But of course, I think I will give a go at it.
Right.
Yes. Yeah. And then there's a trademark. A trademark, for example, when you've come here, trace.
The T.
The trace.
Yeah, the trace logo.
When I look at that, I identify that as a trace. So that's a trademark. That's another element of IP. There's another element of IP we call just closely related to a trademark. We call it a geographical indication.
Geographical indication. First time I'm hearing this. What's that?
That's why we're here.
Hey.
That's why me and Liz are here.
Tell me.
So geographical indication simply means, for example, goods that come from a certain region. Right? Champagne only comes from a Champagne region in French.
Yes.
Scotch only comes from
Scotland.
Whiskey with KY comes from Scotland. You know.
Bourbon.
Yes, bourbon American.
Yeah.
So particular region.
Yeah.
And it has basic characteristics that are very unique to that region, either the culture, either the environment, the climate, and such forth. So that is closely related to a trademark. Then
so let's take that a bit further, right? Okay. So say for instance ningi hapa River Road, nianze kuwatengenezea bourbon. I can be sued for that?
Badly. Anti-counterfeit is going to come for you. Kenya Industrial Properties Institute is going to come for you.
Are these real people, ama you guys just unajua pia Loina said, you know me by the today I'm here to ask all of the questions ile watu huko kwa ground wanauliza, because here's the thing. A lot of people, a lot of common mwananchi, boss, you guys live in Kenya bana, vitu zinatengenezwa huku and guys don't really care about that.
And I mean, that's why we're here, Liz, right?
Yeah.
To try and demystify all these areas of law.
Because you see, like if I'm a business person, like say Kirinyaga Road, industrial area, whatever, right? And I'm manufacturing these things and I've slapped the name bourbon on it or even champagne or whatever. Alafu some officers come and identify themselves and start to say, oh, you've broken the law.
Let me make it even more interesting.
Yeah.
I come from a place called Machakos. And my constituency is called Mwala. And in Mwala, there's a place that is very famous for wood carvings, because the culture was imported from the Makonde people in Mozambique.
Yeah.
And they came all the way. And that aspect, that skill was inculcated to my people. So all the wood carvings, the best wood carvings you get, they come from my place.
Okay.
The same thing, we have the soapstones of Kisii, right? Because there's a certain skill that has gone into making of that. And there's a cultural aspect to it. There's a lot of tradition that has gone into it. The same way we drink Darjeeling tea, right? Darjeeling only comes from India, a certain part in India.
Yeah, a certain part, yeah.
Yes. The same way Moratina is...
Hapa hivi Muranga, Tetu, nini?
Tetu, yeah. But of course, those ones, because now in Kenya we don't have a geographical indications. So those are some of the things that we are grappling with.
That's the thing.
Yes.
Now, I'm glad tumefika hapo. Now, Liz, to you. Huyu ameharibu mambo, first and foremost. So watu hapa Kirinyaga Road, they're just like, hi, what's this man saying? Now, I wanna use what Mutua said, right? In terms of that geographical indication, and I go back to like things that we've had, and like we speak about the Kiondo, for instance, right, or the Kenyan bracelet, or what is it that we're very famous for exporting? So many different kind of things, but let's use Kiondo.
Yeah,
I feel like that matter, it's gone above the heads of a lot of people. So let's use that to explain what exactly happened. That case was in the papers, it was everywhere. So what happened to Kinaga Ubaga?
So first of all, media misreported.
That's the thing.
Media misreported. So let me just go back to putting things together.
Yes.
In terms of what is IP. So in IP we have industrial property and copyright. So copyright is separate because that artistic expression of ideas, that's the threshold. And then under industrial property, we have now the patents, which people love to hear and love to misuse. And it's a highest form of protection. It means it's a novel idea, never been seen before. So that when your innovation is for the first time being experienced in the world, then you qualify for it.
So let's use examples for that. Like say for instance, when Mark invented Facebook.
That one is more on the software side. But with patents, especially let's use a Kenyan context and the Commonwealth type of countries. Because for us, we look at the novelty, newness, and what we call industrial applicability. In the US, they just look at usefulness. So it doesn't matter, like it can just be it's useful, but it's useless. I'll give an example. Like there's a guy who got a patent for a nose-picking stick. Tuko na handkerchief, Calvin.
Hey!
Sell invent a nose pick, akapewa patent in the US. Ikikuja Kenya, the chances are he wouldn't get that.
Okay.
Right.
Yes.
So as we look at industrial applicability, so it's a lot of mechanical type of innovation, scientific, nini. The first time my bike was invented, there was a patent for it. The first time a phone was invented, there was a patent for it. There, and then you invented like here in your mobile phone, there are over 3,000 patents.
I can imagine.
Yeah. So kila mtu, there's someone somewhere akona patent, and then they came together and created something together. But generally, that's that's how patents become. And then you have exclusive use for 20 years. Then after that, it goes into the public domain.
Okay.
So in your public domain, now it's free for you to use. It means now you can start reverse engineering, improve it, nini. But if you do that within during those 20 years, then you have to seek permission from the patent rights holder. Yeah, because now you're using his patent and you're advancing it, because you'll already rely on the technology or the whatever he has created, the novelty. You have to pay them for that. So you have to have a conversation, and they say, okay, I'll license it to you. You'll pay me every 3 months or whatever. This is how you pay me, percentage or a. But the public domain is now what helps now everyone else to start recreating around it, making it cheaper and easier and whatnot. So tumalize tu, so kuna patent, and then kuna trademark. He said a trademark, right? Then we have now the GIs, geographical indications. We don't have them in Kenya, but a lot of European countries have it. India have it. Africans, for some reason, the uptake has been slow, yet it's important, because look at Ketepa tea and so many others. Then we have what we call industrial designs. This protects now the aesthetics of something that you create. So like this chair, if it's the first time I'm creating it, the texture, maybe how I'll put the fabric or the textures I'll create, and maybe it's like an interesting zigzag or whatever. Those aesthetics are protected by industrial designs. And then we have now outside that we have what we call sui generis type of. So GI is one of those what we call sui generis type of IP protection. So sui generis basically mean it didn't fit in the traditional, which is copyright, patents, industrial designs, trademarks.
Okay.
Yeah. So then now we have the GIs, because we're talking about the geography of the place. Maybe the soil has certain attributes. It will make your orange juice taste different. Then you'll call it, I don't know, Kericho juice, because the soil has something to do with it, the climate and whatnot, Then we have traditional knowledge and cultural expressions, leading now to your question. Yeah. So again, now this is another area where now we're talking about community asserting rights over certain properties.
Yes.
Yeah. He's talking about their carvings and whatnot. So now that's where we talk about now the Kiondo, for example.
The Shuka as well.
And the Maasai Shuka and whatnot. So it's about now community asserting their rights and saying, this is what we own, this is how we own it, and things like that. Again, TK is a bit held up with, there's some certain assets. Of course, there's that issue of, we've interacted with other communities and whatnot. We're yet to have those candid conversations under TK and TCEs. But it's there. So, but there are already those things that we know there's authentically ours. If it's if in terms of basket, like basket is really misunderstood. It's a universal thing.
Yes.
It's just that how it's made in different communities. And like what happened with the Kiondo story, someone happened to be in Japan, and I think they saw a Kiondo somewhere, and then I think for them at the time, because this was in the 90s,
yeah.
So I think it was just one of those, Mzungu is carrying a Kiondo, So I think that excitement of the media, so they decided, these guys are selling it, they've patented it. It's not the case.
Okay.
And then with the baskets, it comes down now to the name, the branding, and then the know-how. So like if you look at the Kenyan communities, for example, the Taita basket where I'm from is very different from the Kiondo in the Kikuyu community. The weaving technique, the materials we use, even the patterns and whatnot. And then you find even there's some communities, I'm sure, they have a certain attribute to the patterns they would put on their baskets and be like, this is a basket for a young girl who's 20 years old. This is a basket for a mama who's married.
Yeah.
Like there are those kind of things. So the thing we really now need to work on is that documentation. Yeah. Again, within our tribes, we have sub-tribes.
Yes.
Look at like the Kalenjin, for example.
I think 9 or something.
Yeah. Look at the Mijikenda.
Yeah.
Then in between, they have those tribal nuances.
Yes.
So we have a TK Act. The challenge has now been, we are yet to pass the regulations. And then now we start empowering communities to document. Because remember, again, with traditional knowledge and cultural expressions, it was about word to mouth. Your great-grandfather told your grandfather, then your grandfather told your dad. then your dad has told you something.
And
You
that,
don't know
that
if you-
whole apprenticeship kind of thing
that
going
kind
on.
of thing.
Yeah.
So now we need to like document it. India has done a perfectly good job at
India
it.
with 3B people.
Yeah. Like there's a whole website. If you go online and just try to Google search
Yeah.
TK TCEs India. Like there's a whole website. They'll tell you about their hubs. They've even had, big pharma use some of their hubs and then try and get patents. So then that's how they fought them. And then as they fought, they collaborated.
Yes.
Because I don't say other things. CCKOT, we just bash.
No.
We don't see collabs.
IPs and the SDGs. We're going to get into that, bringing our common future with innovation and creativity. Now, you guys have said a lot of brilliant stuff. I love it. But it sounds very expensive. It really does. Like, I'm not going to lie. Like, if I'm picturing, I'm that person listening on the other side of the radio, and I'm listening to Mutua and Lise articulate this very, very well. And I'm thinking, I'm in school or I've just finished Najaribu. I'm trying to hustle. And I've got this brilliant idea or something that I want to innovate. And I'm just thinking about this process of how long it will take. Should I go ningie uku kwa streets and I do what I've got to do, or do I need to come get you guys, the lawyers and the IP people, and talk to you? Like, how do I go about it? Because at the end of the day, these are the people and the ideas that we actually really need to protect.
Yeah. I'd say this. First, get a lawyer. Because you see, this is about ideas.
But
yeah,
expensive.
It's the expression. It's not expensive. I'm getting there.
Okay.
I'm getting there. It's not. So, first of all, if already you're like, OMG, this is revolutionary, right? So you want to protect it. And the first mistake guys usually do is, I'll call Calvo, my boy, and say, hey, you guy.
Kuna idea hapa. Hey.
Then Calvo will do the thing.
Yep.
And he'll just snook away and do something. So
Yeah.
first go to a lawyer. This is what we call protective lawyering. This is where we are very affordable. There is no 911.
Na najua mnakuaga na nini inaitangwaje red card. Hiyo hebu tuambie. Hiyo ni how much?
Itavari na wakili and expertise nini. But tutapata between even 3K, 5K, 10K depending on the expert level.
Thank God. Okay.
Utapata that preliminary advice.
Fuliza hiyo.
Unacheki?
Yeah.
So during that preliminary advice, I tell you, okay, this is what you have at hand. Usifanye 1, 2, 3. Like one of the things we'll tell you before we register, please usieke Facebook, IG, X, because of course you will destroy your novelty. Nini. Competitors will know. Jump on it. The guys with money, they will jump on it and.
In layman terms, you've jinxed yourself.
Exactly.
Yeah.
You'll have jinxed yourself. So kuja for that preliminary advice. It's
Okay.
affordable. And then after that, we give you a plan. An IP lawyer now will be able to give you a plan, and even you're open about your challenges. Kuliko you start, because I know when you do this entrepreneurship courses, they always tell you just start. Yeah, it's fantastic, but IP law, the law is the law.
Yes.
Yeah. So, and I tell guys, as now you're given that blueprint, because of course kutakuwa na maybe say trademark, you've branded your product, nini. It's either I don't know, like hair products. Hair products are really big right now.
Yeah.
So let's say you have a hair product. You need the trademark. We need to figure out what to do with the formula, because I have to tell you about like patent. You have to do what is called disclosure. Disclosure means everyone will know what goes into your formula. So you have to make that conscious decision if you really want a patent, or do you want us to go through what we call a trade secret.
Okay. Before I you know me, I'm a very genuine guy on the radio.
Yeah.
Hapo umenipoteza kiasi, because when you said that disclosure,
Yeah.
I instantly thought Colonel Sanders, KFC. We don't know what the herbs and spices are.
Yeah.
And Coca-Cola.
And Coca-Cola.
That's the most famous
Trade
one.
secrets.
A trade secret.
So a trade secret means basically now it's a kind of contract. Contracts will draft for your employees and the people you work with, your distributors, anyone who's interacting with your formula and stuff, so that we make sure they can never cough anything.
You're bound.
You're bound. You will die with that secret. Coca-Cola has been in the business for how long?
Ages.
How many people have tried to crack it?
They've done a successful job.
Exactly. The contracts they have, Simchezo, like they can't even have two guys working for Coke in the same aeroplane.
I've heard that, yeah.
And there's a funny story. There's a guy who tried selling the Coca-Cola formula to Pepsi. And as they were having the negotiations, the Pepsi guys snitched him to the Coca-Cola people. That's how... Yes.
That's deep.
Yes.
Where?
Yeah.
It's crazy.
Interesting.
So that preliminary advice is very affordable because now you're able to panga yourself. And I think creatives need to understand whatever craft you're in, music, fashion, film, in the biz, you have to spend money to make money. That's the basic principle of business. So it's figuring out how do you tap into even the resources around you.
Yeah.
But ukipata hiyo 5K, ingia kwa ofisi ya wakili wa IP. Yeah, and then they tell you, okay, this is what you need, nini. They'll even project the kind of financials. And lawyers are humans, so we can even negotiate as well.
But you see, you still haven't answered my question, right? Because I feel like there needs to be more pro bono stuff for this kind of stuff. Because here's the thing. There's so many young people out here who have so many dope ideas and everything, and they're getting shafted left, right, and center. As you said, msee anakuambia, hey, do hivi pap, hii idea ishago. It happens so often. You understand? But I said pro bono, maybe I don't know whether there's lawyers who are actually giving this.
Calvo, just before you get to the pro bono part, when you go to a doctor, do you tell him, treat me for free?
Oh, here we go.
No.
No, chokweli.
Chokweli.
And you see, this is the thing.
Nyemnaenda strike lini?
The creative sector, the kuna do.
Yes.
And we're not saying, okay, so I feel like the word pro bono, we kind of misusing it in, especially in the creative sector.
Yeah.
I'm like, Harry, you come and tell me, Liz, this is the issue at hand. Help me secure something and I'll pay you. Kuliko telling me I'm giving you for free. The minute I'm telling you, Kalumi have done pro bono. Ikafika point, I'm the one who cares more about this jobo than the artists themselves or the rights holder. Because ajeka do. Ataka 5K.
So I
feel your story.
Okay.
Ana
they're just like whatever.
Kama ni litigation hata wiki court fees. Then the day you need him to sign a witness statement, nini, a guy's like, oh, sijui niko Vasha, niko sijui wapi, oh, I'm drunk.
It's a hot mess.
It's crazy. So people need to be invested. And the way we've seen so far now, it's if you put in a sweat there, it's some chums, then you're more responsible.
All right.
Calvo, what Liz is you see how she's deep into the creative sector, so she can't afford to throw a few stones.
Yeah.
Creatives operate in a very laissez-faire attitude, right?
Yeah.
And from where you sit, that needs to change. I would prefer, as a creative, create, but look at the creations that you're doing as a business, and look at all the facets of a business. Whether if you have to look for insurance, look for insurance. If you have to look for lawyers, look for lawyers. If you have to look for accountants, do that. Look at it as a business. And just to introduce something so that now Liz can hammer it home. If you want pro bono, guys do pro bono work. Record labels do that. And you see what happens.
Well, actually, but he's just hit the nail on the head.
That's it.
It's dangerous. And you see, look at it this way. If you're going to get into a business with another guy, and this guy has a lawyer, why don't you have a lawyer?
You need a lawyer.
You need a lawyer.
Yes.
So they'd figure it out. Yeah. Like I said, it's about figuring out how to leverage a relationship.
So in terms of, you guys have been in the business, in the craft, you're speaking to creatives, you're speaking to guys who are innovating, entrepreneurs and everything, right? Have we advanced in our IP protection, or just guys taking intellectual property seriously?
I think mali tumefika, people have advanced. Because laws, Sharia tuko nazo, we have very good laws.
Yeah.
We're just now updating, keeping up with international, standards and upcoming things, if it's AI or whatever, all these new things that are coming up. But we have good laws. And Kenyans have figured a point, they've realized, I need IP. And also remember, now we have a lot of foreign companies also, looking into Kenya and Africa, and they are interested. So a few people in the beginning, they were snookered, they lost. So people started learning. So like now, when you look at even like say Kenya Industrial Property deals now with the patents, trademarks, and whatnot. If you look at the trademark register, we have a lot of locals now registering their brand names and their slogans. Because they realize what that means. Yeah, we are trying to do better in terms of patent protection, but a lot of utility models, those now what we call petty patents, improvement on an already existing patent. Kenyans, they've registered quite a number.
You said Kenyans are registering, right? And I want to use an example. Shot going out to Willis, right? So Willis and the name Bazoo. So what essentially should have happened is someone should have taken time and searched. Is that what you're saying?
Yeah, I think they should have. So, but again, when
Mutua seems to have a different opinion.
No.
What's your hot take? What's your hot take before you use it?
I don't really have a hot take.
Yeah.
It's just that I've not read the decision, so it would be not so wise for me to give opinions on live on air about the decision. But I've heard a boy talk, and there are a few things that are not right with the decision. But I will leave it at that. Yes, for now.
Okay.
So, but let's answer it this way, though.
Yes.
If you're going to use a name for a campaign, or even you're branding your business, you want to check if there's anyone using that name already. Yeah, because once you start investing in it, you create what we call goodwill. Sindio.
Yeah.
And if someone already has registered it and is using it, there'll be goodwill, and they will, if they are able to prove that confusion, that a consumer, so maybe Trace with a K, and then they're pronouncing it as track or something, but like similar font, the minute a consumer or a number of consumers will say, actually I thought that was Trace FM. Yeah. The minute that confusion is proved, there's a problem. So it's due diligence as you're branding. You always have to do first two searches, a preliminary search online in Inini just to see.
Yeah.
Then now you go to Kipi and do a search to confirm if that mark has been registered.
Yes.
Now with trademarks, we register them in what we call goods and services, under goods and services. So depending on the biashara you run. So like if I sell apparel, I have a different class. If I'm an entertainer, I'm an MC, I have a different class. So I'll apply and say, I want to know if Calvo is registered under class 41 for entertainment services.
Yes.
Yeah. So the minute I see it's available, then immediately I'll register Calvo Entertainment or Calvo MC or something, right? Then from that, now I can invest, I can market, I can do whatever, because now I know I'm solid. Yeah. Unfortunately, most guys are just like, they have Zakawad, they decide, you start marketing, then the next thing you're slapped.
So
Calvo, just so that we don't lose a point, just after the Bazoo decision, or before the Bazoo decision, your president purported.
Listen, don't put me in trouble. The president, His Excellency.
His Excellency.
Yes.
Or rather, the president's lawyer purported to register a mark on that Mambo ni Matatu statement. Yeah. And from a practitioner's point of view, we had a bit of reservations. One, you registered as who? Are you registering as the President of the Republic of Kenya? Because when it was advertised, it has His Excellency, the President of the Republic of Kenya. So, words and speeches from a public official, especially at the highest level, many times they fall in the public domain.
Yes.
Right? Now, when you also go in the intricacies of trademarks, you can't trademark an offensive word. Because how was that word said? It was not said in the best of in the best of the speeches telling Kenyans about floods. No, it was said in the most.
So there's ethics behind this.
Yes.
Oh, this is interesting.
So when you purport to register such a mark, as a private person, maybe, as the President of the Republic of Kenya,
not possible.
Yeah.
What about Allah? Same kind of.
So here's the thing, though. When our leaders are registering some of these trademarks, you ask yourself, what is the end goal? Because trademark is about trade, it's about branding. It means then you have to do actual use. I did a blog on Allah, lizlenjo.com, so guys who are listening can log into that. I went into detail.
Well, tweet that out, huh? Yeah.
But basically, it's about how you use it, right? So like now, I think he included the class on apparel. So have we seen any tissues by
There's
Mr.
obviously
Atwoli.
we haven't. But there's
right?
definitely guys in Tao who've printed those things. Well, back in the day.
So but you see, it speaks to now the commercialization value and whether it makes sense. So we would love to see now that, right? But I know for him or for most public officials, the misunderstanding is that once I trademark it, I will stop you from using it. But in Swahili we call it simo ya mshangao. Ala?
What?
Simo. What's the difference between alama ya mshangao and simo?
It's like semantics.
It's the same.
Yeah.
Okay. Yeah.
So it's an ordinary word. So it's about how you use it, right? So now it would be, we're still waiting to see how he uses his trademark. Because yes, you've registered, and then what? And that's the thing even for creatives generally. When you're registering IP, you better have a strategy. Because you don't register it and then it just stays under the desk, or your certificate is in your desk waiting for someone to come and help you or something. Like, so you want money, that's the end goal. So now, when you're registering, you have a strategy. That boils back to now that preliminary advice. We're able to tell you, this name won't make sense because either it's derogatory. Remember, IP is territorial. You tell me I want to go to Rwanda, I tell you in Kinyarwanda this word has a different meaning. So if you have to go to Rwanda, you may have to rebrand because they won't accept it.
I feel like I'm having a fireside conversation. I love it when they use that. Like, like you go for some of these symposiums and they tell you fireside. Nakuna moto. Fireside chat. Nakuna moto. You're just like, bro, where's the fire? All right. Right here on Fast with the Hits, Trace FM. It's International IP Day, and I am joined by Liz Lenjo and Mutua Mutuko. We've been having a conversation about so many different kind of things, and before we took that musical break, I threw in content creators, right? And the question was to do with, so we have a lot of influencers right now, and some of them get ideas from just like, someone in the States or whatever part of the world, right? And they've created a video that's gotten so much traction. This is the idea, what. And then they take it and they, give it their own kind of like, face and music and all of that. But the idea ni ile. And it got me thinking, are we going to get to a point where you could get in trouble for that? Because here's the thing. As Mutua said, it has already come from the head. It's now gotten onto a medium. This medium is now social media, and we've put it out there. And it's probably started to generate like a lot of what do you call it? A lot of money and all of that. How does that play out?
So let me now advance that conversation around copyright.
Yes.
So the copyright, what it does, it protects the expression of ideas. So of artistic value, but the expression of ideas.
Yes.
So and that's why, like, if you look at soap operas, you find the themes are usually similar. Sindio, mother-in-law, beautiful chick, the father-in-law falls in love, a poor guy falls in love with the rich daughter or an heiress. Like, that's right. Those are the general ideas. So it boils down to the expression, how the scripting was written and how it was acted. The music they use. So that's what we call expression. So it's the same thing now, because at the end of the day, copyright is also shaped by how we do things. So if it's quote unquote like a story around adultery, it's the same thing that will be done over, like it's stories that are whatever's, yeah. So they are more like concepts or ideas.
I've never thought.
They are just raw.
When she said adultery, I've never thought about it.
So you find that now it's how you will express it. So if it's let's say one of our influencers decided to let's try and see an interesting.
Let's use like Mr. TID right now. Why are you passing in front of my interview? That kind of thing.
Yeah. Well, that one. So I mean, if okay, so that one is interesting because there's that, and then now people have now been doing what we call parodies.
Yes.
Yeah.
Yes.
So a parody falls under an exception. I don't need permission from the person to make fun of them. So it's a parody.
Yes.
But then again, also, I think in my view, we need to start challenging parodies more a little, because some people are going to the extent of now commercializing these parodies. Yeah. So are you saying that then the original rights holder shouldn't get a slice of the pie? But we don't have a lot of our artists also, because again, the issue of understanding, and also the pool of lawyers around copyright IP in general, hatuko wingi. So, but it's just that. But say like if you just, say like you've been seeing the content from This Is S and Victor Peace, and they're finding very interesting ways to do it. So if like what they did with the mattress, and then someone else, another influencer is doing for another mattress, and then maybe they decide they're caught up in a storm, like the way now it's raining in Ai, and then that particular mattress allows them to sleep.
It's waterproof.
To sleep there on it's waterproof or whatever. You see, it's the expression.
So how you flip it.
Yeah, it's how you flip it, and you give it your identity, your character, and whatnot. So you can never claim exclusivity over a concept.
All right.
You cannot, because if we start claiming concepts, Itafika Mali, we can't innovate. Yeah, exactly.
So, Kavo, there's a very thin line between borrowing ideas and copying. Extremely thin, and depends on how you're going to interpret it. But just to convert to keep on getting to this conversation deeper about content creators, the best person who's been giving these people sleepless nights is one Hobart Nakitare.
Shagaratu Nonini. Are you his lawyer?
No.
Okay.
It's Kate. You know Kate? Yeah, it's Kate David.
Okay.
So he's been he's been on a crusade, and rightfully so.
Yeah.
So we need to you see guys have always content creators just think of themselves as just content creators.
Yes.
They never many of them, they never look at it as much of a business with all these things that you've been talking about. They just think that maybe this is a preserve of this is a preserve of I trademark my name. No, for what? ISG. They also we need to start advancing these conversations with them as well, because there's liabilities, and there are times you find that in some of their contracts with the clients are heavily indemnified. Very indemnified. And then when you're told by court, please pay Nonini some 1.2 million, then you're left, you go to the client tells you, hey bro, we signed an indemnity, I'm already indemnified, you figure out your thing. Yeah.
Contracts. I don't even know what to say, because you mentioned it in the last hour, right? People need to spend that money, that extra 5K or whatever, to actually Liz, you said it off air. Let's bring it on air. Content creators. On the 26th of April 2024, Liz Lenjo on Trace Radio said, when you're getting that money from this endorsement and everything, kindly spare some money to actually sit down with a lawyer. Maybe monthly is pretty good, to find out what's really going on.
Yeah, or every so often. Because like for me, I have a couple of influencer clients, and they're very diligent. But already I gave them such a good primer that already they even know when there's a bad deal on the table. They just call and say, this deal will come, but I wasn't feeling it because you told me 1, 2, 3. See, I was right.
Yes.
Yeah, I'm like, good job, good student, sort of thing. So, but like you said, you have to put money aside. And even when you're just starting out as a content creator, I'll give an example. I won't name the blogger. She's a serious fashion blogger, or was at the time, and she's really good at branding. Everything she touches in aqua gold.
Yes.
So there was a time when she used to do fashion blogging. She had crafted a really beautiful and unique name. A magazine decided to name their fashion pages after her blog. Imagine she didn't know what to do, and she sat. So now, later on, now I'm the one, because I'm a fan. I'm a fan of hers. Yeah. I sent her a message and I said, hey, you have a collab with True Love. Hey, kaching. She's like, what do you mean? She's like, no, I tried to reach out to them. I was like, chick, you just walked away from money. And all she said was like, I can imagine I don't want drama. And I was like, sweetheart, just want to, because you see, also as lawyers, we feed from our clients' desire to win or make something.
Yeah.
And all I needed was for her to just say,
let's go. Damn.
Because Maze, that was money.
On the table.
So content creators, those names they're giving their blogs, those are trademarks. There's some corporate somewhere watching. That goodwill, they will come and dandia it very fast, because you're clueless. Because you're busy saying, lawyers are expensive. Meanwhile, you're wearing shoes for 20 G's, you have a wig for 100K, and you're saying a lawyer is expensive.
It's not.
And then
it's not.
I also don't get this thing about when people start talking about, I don't want drama. Bro, when you don't pay me, that's not drama. When you steal an idea from me, that's not drama.
Yeah,
we just have to make things right. And I've seen especially content creators go on X and say we are blasting this agency for they've not remitted money to us, and just many of them leave it at that. You don't proceed further. If you had a lawyer, they could work magic on this thing.
But let me tell you this, right? So it's easier to put that on X because, at the end of the day, the back end conversations, guys are telling you, boss, if you don't take that down, we had a deal that was coming for you. You're not going to get it. You get. So, and some of these guys know this is where my bread is buttered.
So it's become a strategy.
It's a thing. It happens.
But that's true, though. I've seen it in one or two.
Oh, trust me. I got a call 2 weeks ago from a young lady. She was like, hey, this particular entity hasn't paid me and they want me to post this. And they're just like, and I was like, no, don't do that. Don't. And she's like, but are they going to now, withhold other deals in future and all of that? But, we need that discipline, right? No one should be, the word is bullying.
Yeah,
it actually is,
and
right?
that culture is serious, by the way.
It's serious.
You know how many times I've gotten a client holler and say, Liz, review this contract like ASAP. I have until midnight to accept a deal. I'm like, contract negotiation.
No, it's not
serious.
possible.
Yeah, so I even tell them, stand your ground. If they respect you, they will give you at least 3 days.
Yes.
Tell them we need 3 days to review the contract.
Yeah.
And it's called a contract negotiation.
Yeah.
Not,
a hostile
I give you
takeover.
this, you either sign or I give this to another influencer. No. It's a negotiation.
Yeah.
And then contracts are not oral thing. You do this campaign for us, we're going to pay you 300 Gs, and then that's it. You need to have these things on paper all the time so that in the event that this doesn't happen, if it's less than $1 million shillings, I'll take you to the small claims court.
Small claims court.
Yes.
It works, by the way.
Yes.
I've seen a lot of people speaking about it. The small claims court is an actual thing. Now, guys, as we go on with this conversation, right? There's on X, as you said, and I think Nonini even mentioned it when he was here recently from the States. We spoke about Urban Tone. It's a conversation that keeps on happening. During the break, I just played you guys G-Bag Najat or Jag, which is actually one of my very, very favorite songs. Naliz, unajua tuko ile generation ya TikTok hata mtu watu wa nini kama ulienda, what is that place in Tao called?
F.
Hey boss, hapo.
Okay.
Pale utalii house. Mwendas. Watu wa
yes.
Mwendas. Yes.
It's still one of my favorite places.
It's still there.
It's still there.
Flaming Lamborghini. Unaikumbuka?
Mogash, naked Mogash.
Yeah. That is a whole era. So, so we grew up listening to a lot of TOK, that whole era, right?
Yeah.
And G-Bag na Jag is essentially a TOK song, right?
Yeah.
And I don't know whether they sampled or they've had that conversation with them and all of that, but it's a greater conversation that's been happening. But also why you hear that the Urban Tone guys are actually going for that is because that's a bit far. You get TOK, it will take them a bit of a distance. They can find us if they want, right? But si kama nikitumia ngoma ya like Savara kwa hapa mtaani atabisha mlango yangu aniambia get what's going on. So are they actually, is it right, or how's the way to go about it? Because I'll tell you this, right? When you're doing like video mixes, these guys who are signed to Rock Nation, like Jay-Z, Rihanna, you can't do a video mix with some of their songs. You have to pull it down. Like the way they've instructed YouTube as a record label, like when you look at like a lot of mixes, why don't you think a lot of Jay-Z music is not on mixes?
Yeah.
Your favorite DJ's favorite, yeah.
So let me put it like this: intellectual property gives you the right to control your work. So you get that ownership, and then you get to control. Just like when you buy a shamba, right? You buy a shamba, you work a fence.
Is him a beachfront zakite?
Kumpole. Yeah, but like, or even when you buy a house, you're locking people out.
Yes.
You get to control who comes in, who comes out, right? So it's the same thing with IP. Kasi yako, you have to clear the rights.
Okay.
If this is not your creation and you want to use it, you have to clear the rights. Because copyright inakupatia the right to control. To control means controlling derivative works. So kama hii sasa ni derivative works. So may create a new song but with the original. unacheki, so it's a derivative works based on the original, so lazima kuwe na license, because what happens when you have a license, you have a good negotiating power. It means you will also split some profits or revenue, because you wame invest kwa hii recording, right? They put in money, they went to studios, 3D mixing was done, all that stuff, money was put in that. Now the minute you don't get a license, it's an illegality. You can never benefit from an illegality, which means right now if the music is on YouTube, Spotify, nini, if it's still there, hawaijakuwa taken down right now, it's not there because it's legal. The rights holders on the back end have put mechanisms to make sure the money goes to them. Wow. Chances are they're not making any money because it's an illegality. But ukiwa na license, even them on the back end, they will tell this platform, we have an agreement and we confirm that you give them 80%, you give us 20%. Because you had a negotiation and you're able to tell them 1, 2, 3, we spent X amount of money. For us, we know most of the listeners will be coming from Kenya because we did it in Sheng or whatever. Like you'll have that negotiation and you have an agreement and make that money.
Calvo, just let me pick from there.
Okay.
Just to make it a bit more complex.
I love it.
Copyright has two facets. One is economic rights, and the other one is called moral rights. So economic rights gives you control over how your music is going to be done. If you want to reproduce it, if you want, whichever way it's going to be done, you have the rights over that, right? And you have the right, out of that, you benefit economically.
Okay.
Right? As a rights holder. So, TOK, in this instance, they have the right to say how their music is going to be used, if they're going to accept or not, and they're going to make money out of it. So from where I'm seated, and I have a lot of grace for these kids, I think from where I'm seated, probably they don't have the right people in the room.
Of course.
So there's a lot of advisory that they're not being given. Because look, I mean, everyone samples. Kanye is one of sampling everything.
Greatest sampler.
One of East Africans' best export is Malaika. How many renditions of Malaika do we have? So many. But there has to be a proper way of doing it. Yeah, just don't wake up today and say, you know what, my guy is tufanye hivi. And because you think TOK is across the Caribbean, Jimani hata waambia is, come on. Yeah.
You know what's interesting about that, right? When you've mentioned Kanye West once tried to get a sample from Lauryn Hill. And Lauryn Hill refused. Why? Because Kanye said Lauryn Hill, didn't say Miss Lauryn Hill. She's petty like that. Now, Liz, you sit in the copyright tribunal. You mentioned something. They don't have the right people in that room. From your experience, are you sitting with the music societies, the royalty collectors, all of these different things? Are you guys having workshops with all of these creatives and musicians for them to understand how to approach it?
So let me explain. Under the Copyright Act, there are two entities that have been set up. We have the Kenya Copyright Board, which is now the body that oversees copyright administration in the country. So they do a lot of sensitization around that stuff. And then the Copyright Tribunal now deals with the disputes, the disagreements that guys are having around copyright issues. So that's the difference. However, we collaborate so that then we're telling guys, like Mutua aptly said, registering a copyright is not a must, but we have what we call a voluntary system. So it means that you can decide to register or not. But registration is a more, we say, prudent thing to do. It's the right thing to do because it shows your proactiveness in asserting your rights, in saying ini yangu, right? Just the way you will get a shamba and get a title, it's the same thing with copyright. You want to do that because it just shows that you are proactive. Yeah. So like now in that instance, for now as a tribunal, how we would come in is, let's say you and I do a collab, or the three of us do a collab, and then you go and register and the certificate comes out in your name alone and us we were co-authors. So that is a case you bring to us. Then you're saying this registration is it's not valid because we were part of the writing team, we did the script with Calvo, akatutoa ndio hii evidence, emails nini, maybe you even did recordings you've been sharing on WhatsApp, enough evidence. So as the tribunal will now revoke that registration and order a new one is done with all the rights holders in place so that you are identified. Because what will happen is now, if let's say this script is picked up by KBC, Netflix, or whatever.
Yeah.
We want to get paid. And one of the things they will ask for is able to show us the proof that you wrote this work, that
Yes.
this is actually your work. And you see, like in film, we have a whole thing about agreements. We call chain of titles. Everything that's created, lazima ushow proof. If you use ukitumia ngoma kwa film, you have to have a contract to confirm that you talked to Nyashinsky to use his song, for example, or you talked to Bien na mkaagri kwa contract that you'll use the song in this film, and you're even specific. This is the scene of the film, nini, the whole shebang.
That musical scoring. But funny enough, I was talking to someone in film, and they said they'd rather get a person to produce original.
Yeah.
They tell you, hey, here's 2 million. Give us 21 tracks that will be used as musical scores. Like The Gentleman, the new show. Who's the art producer? Guy Ritchie. He works with a particular guy to design, to produce his whatevers. But anyway, I digress. You guys can tell me what we haven't touched on, but before we even get there, this I feel is for my own benefit, because tumesema leo nauliza maswali. There's a movie I was watching, the Gucci story. You guys have watched it? The whole story about House of Gucci?
House of Gucci.
Yeah. There's a scene where, I think, is it in New York, where there's all of that bootleg, the Gucci bags and all of that. And he goes to, was it the father or something? And he's like, why is there all of this bootleg and you're not doing anything about it? And the guy so aptly said, no problem. Let them do it. I'm trying to understand why some of these houses don't have like a severe crackdown on like the bootleg. And it's been there for years and they let it thrive. But last year we also saw a law where some countries were saying if you come in with a fake bag, they'll take it. They won't even allow you into. Yeah.
So here's the thing though. You see, like IP says, it's about your right to control. You decide. That strategy is slowly changing, especially with fashion brands.
Yes.
Because now they see that even in the African continent, especially, they're losing a lot of money on counterfeits.
You know, when you're wearing Bior instead of Dior.
Or Adidas.
Which is your favorite? It's between Mob.
I know, right?
Shagwena to what's that?
So, but this is the rationale, especially for some of these high-end fashion houses. Their audience already know who they are. They've already understood the brand. They know what they love about the brand. They know about if it's the stitching, the design, nini. So they're like, if I know my client would get confused, he knows my bag is $1,000, and they definitely know at $5 or $15 that's not legit. So some of them you find that, but I think over time I'm seeing a lot is changing. I'm a member of International Trademark Association of trademark attorneys globally.
Yes.
So those are some of the people I interact with, these heads of legal in some of these international brands. Now they're seeing how things are becoming really bad, and unfortunately also with like the counterfeit industry, you'll find that that man is going into doing even more illegal things. So like we've seen we've seen like a company like Shane has been on the spotlight for a while, and they do some serious copying.
Yes,
they do some serious copying. So even now, like, guys will buy, but if you're not a fashion connoisseur, you'll just be like, it's a beautiful dress. Some of us are like, I know who you copied. So but now we are working with some of them towards trying to streamline some of these things, because at the end of the day it also affects how even Kenyans interact with IP. It affects our businesses as well. We're always saying, in international, hainidhuru, but you would be surprised, because the minute a Kenyan will buy a knockoff Gucci, why wouldn't they buy a knockoff
whatever?
Say Icon, for example.
Yeah.
What will stop them from getting one of Joki's designs? Uko Backstreet.
Calvo, just from what she's saying, I think there are a few things that we've done right, and a few things that you're not doing right. Just to take care of that, I think the government hived off something from Kipi. They created an anti-counterfeit agency that has been flexing a bit of muscles here and there.
Yeah.
But one of the things that I've been on a crusade on is Once someone is found guilty, I'm a big fan of don't just fine them. Tell them to account for profits. How much money
did you make
from the knockoffs?
Yes.
Then can we find a way of taking that away from you? You see the way EACC,
yes,
once they come for your they figure out that you've had, they freeze your assets, and they take the assets that were made as a result of that.
Yes.
Why can't we keep having such conversations? Because remember, as you're saying, we have a very good regime, and when some of these entities are coming to set up in Kenya, one of the biggest conversations that they are having is, how is your intellectual property regime? We've been a lot of back and forth with the US on getting a new trade deal. We've been having conversations about the African free continental trade deal.
Yes.
One of the sticking points is intellectual property law. They want to know how, compared to us, are we going to come here and struggle? So those are some, it might look like a very mundane conversation, a very simple conversation, but it has repercussions. Yeah.